Morning.
Good morning.
Looks good there.
Mr.
Good morning.
Spitzer is clearly more savvy than me because I could not have moved myself around like that. So great job.
Well, I was very impressed too, although I was like, wow, he's just floating around out there too. Well, good morning to you all, and thank you for accommodating the court's schedule in regard to this matter. And I also want to thank Judge Craig Baldwin from the Fifth District for sitting on the panel here today for us. The only case we have on the docket is the City of Barberton versus Summit County. And gentlemen, this is being recorded, as you know, and we're live streaming now. So hopefully there won't be any problems. But if you can't hear or something's going on, please raise your hand or alert us some way. And this doesn't apply to this case, but we always make an admonition that we're not allowed to, the attorneys or the judges try not to mention victims' names or the names of children. And you each will have 15 minutes. And the appellant may reserve up to 5 minutes. So when you are ready to proceed, we are ready to listen. And
Thank
I'll
you.
be
May it please.
Mhm.
Thank you. May it please the court. My name is Gary Corrado. I'm here this morning on behalf of the City of Barberton. I'd like to reserve 3 minutes for rebuttal, if I may.
That's fine.
The issue presented in this case is, must the county house at the county's expense individuals that are charged or convicted of state law misdemeanors by municipalities? This issue is not an issue of first impression in the state of Ohio. The exact issue was analyzed and decided in 2017 by the 6th District Court of Appeals in the case of Toledo versus the Corrections Commission of Northwest Ohio. In that case, the 6th District did a detailed analysis of the applicable statutes and held that the county has the obligation to bear the costs of housing individuals charged with or convicted of state law violations in a municipal court.
Counsel,
Yes.
Counsel, before we go any further, I just want to make sure I'm understanding the procedure posture here correctly. Do you agree that the court dismissed this case?
Yes, the court dismissed the case.
So there were actually no declarations or entered.
That's correct. We never got to the stage where we could present evidence.
So the court, the way I understand it, the court said this was not, I'll use the term jurisdiction loosely, but the court did not have jurisdiction to proceed.
I understand it actually that the court ruled as a matter of law that municipalities have in these instances only two choices. One is to either operate their own jail to incarcerate misdemeanants or contract with the county to provide jail services for misdemeanants. There was a standing issue, but that issue did not relate to the city of Barberton. It related to, the complaint was somewhat expansive and there may have been some confusion. And the court said that Barberton does not have standing to bring claims on behalf of other municipalities or citizens or townships in Summit County, that Barberton only had standing to bring a claim on behalf of Barberton. So that was the only jurisdictional issue, Your Honor.
Well, and that's why I say I refer to jurisdiction loosely, because obviously in order to have a declaratory judgment, as the court indicated, the trial court below, it has a whole section on declaratory action standard and goes into whether the matter is properly before the court and justiciable. I know I can say the word justiciable. So, but that's fine. I just wanted to see what everybody's position was with this.
Sure. But the very interesting thing is that the exact thing that the court held here and the exact holding that the appellees had urged, this holding that a municipal corporation has only two choices, and primarily this is based on 753.02A, that a municipality must either operate its own jail or contract with the county to provide jail services, was the precise issue that the 6th District looked at in the Toledo case and expressly rejected. And once that decision came down, Lucas County filed a jurisdictional memorandum with the Ohio Supreme Court, and in that jurisdictional memorandum makes the same arguments that the appellates make here, including arguments that, this is just simply a charging decision and Barberton can't shift the financial burden for housing people simply by making a charging decision. The arguments that this is going to be a financial catastrophe for the counties, et cetera. All those arguments were made to the Ohio Supreme Court, but apparently the Ohio Supreme Court was not persuaded by those arguments because it declined to hear the case, and it allowed the 6th District case to stand.
And I understand what you're saying, but obviously the Supreme Court, the Ohio Supreme Court, has said we're not to take anything from the fact that they don't accept jurisdiction or they, want a case. So the ruling would remain law of the case, obviously, but we're not supposed to speculate, are we? I don't think.
Well, no, I understand, but yeah, there was an attempt made to challenge it. It was not accepted, and now it's remained the law, at least in the 6th District, for 7 years undisturbed, and undisturbed by decisions in any other district in the state of Ohio.
Now, with the Toledo case, as the other side points out, that did not involve a situation like we have here where the municipality was actually running a jail.
That's correct. But that is, Your Honor, we submit that's a distinction without a difference in the analysis that the 6th District made. If you look at that, and that discussion and the analysis happens at paragraphs 30 to 32 of the Toledo decision. And basically what it says there is it's talking about who has the financial responsibility to house people in a municipal jail. And that's not the issue here. The issue here, is who has the responsibility to house and pay for people that are charged with state law violations, state law misdemeanors, not who has the responsibility to pay for individuals who are housed in Barberton's jail. So what the court says there is, yeah, if there's people that are housed in Barberton's jail, even if they're housed there for state law violations, because they're housed in Barberton's jail, 753.02A says Barberton pays for the people in its jail. Barberton doesn't argue that, and Barberton hasn't asked in this case to be reimbursed for people held in Barberton's jail, whether they're there for municipal ordinance violations or state law violations. But if you look at the actual analysis that the court goes through, it spends, 5 or 6 pages analyzing 753.02A and comes to the conclusion that statute neither requires a municipality to operate a jail, nor does it require a city to contract with a county to provide jail services. And so, so clearly Barberton is not required to maintain a jail. We know that from the plain language of the statutes that all use when talking about municipalities and jails, it all uses the permissive term may. But in addition to that, we just know there are many, many municipalities in the state of Ohio. Most of them do not operate their own jail. So there's no requirement that a jail be operated. So Barberton could shut its jail down tomorrow, and it wouldn't have any impact on this case or the ruling necessarily that this court makes.
Why,
And so,
if that's the case, why did the city feel it necessary for the court to declare that Barberton did not have to operate a jail?
well, because again, because the decision out of the sixth district we know is not binding precedent. So we wanted that decision to be made here in Summit County and then potentially in the ninth district. So it becomes binding precedent here. I think we think that's kind of one of the steps in this analysis, but we do recognize that that's persuasive authority in the sixth district and not binding here. The issue becomes, and I think what is interesting is that the trial court and the appellees, they try to brush aside and bat away the sixth district's decision in the city of Toledo, but they don't attack the analysis. They don't attack the rationale. They simply brush it aside by saying it's not binding here. And they raise this distinction without a difference that Toledo didn't have a jail, but Barberton does. But nobody challenges that the sixth district analyzed the statutes wrong, looked at the incorrect statutes, had a flaw in its analysis or its conclusion. They really don't deal with the case at all. They brush it to the side. And I would suggest that the reason for that is because the sixth district did an exhaustive analysis of the statutory schemes and came up with the holding that it came up with. And as I said, it looked first at 753.02A and found that does not require a city to operate a jail or to contract with the county to operate a jail. It then went on to look at, then, okay, how do we apportion the expenses for somebody charged with state law violations between a municipality and a county? And it looked at revised code section 1905.35, and it went through an analysis of that code section. And 1905.35 says in its plain language that a municipal corporation must pay the cost of housing persons convicted of city ordinances by either incarcerating them in a city jail or contracting with the county to provide those jail services. The court looking at that said, well, by its plain language, it does not include housing state law violations, and it does not put on the city the burden of paying the cost of housing misdemeanors charged with state law violations. And then it applied the longstanding rule of statutory construction of expressio unis est exclusia alteris. The express inclusion of one thing implies the exclusion of the other, and determined that because the state legislature did not place the financial burden of paying for the incarceration of misdemeanors on municipalities, then that responsibility must lie with the county, and that the court would not add to the statute a requirement that municipalities take on that burden. The other criticism of one of the criticisms interposed by Lucas County, it's not been interposed yet here, is that 1905.35, that statute's found in the mayor's court section of the Ohio Revised Code. And the court found that, well, that's immaterial here because we're just looking at the plain language of the statute. We don't need to even interpret this statute because its meaning is clear. And it does not say that it applies only to charges or convictions coming out of a mayor's court. So,
Counsel, I want to alert you that you are entering your 3-minute rebuttal time.
Okay, thank you. So, Your Honor, we think that the sixth district's reasoning, although not controlling, is certainly persuasive. We think it controls on this issue. We think that that reasoning ought to be adopted, particularly since nobody has been able to take issue with or go through that reasoning and disagree with it. So we asked this court to reverse the trial court's decision, remand the case with instructions that the court enters declaratory judgment in favor of the city of Barberton. Thank you.
Thank you. And counsel for the appellee, you will have 15 minutes.
Thank you, Your Honor. Good morning, Your Honors. My name is Ryan Spitzer with Isaac Wiles, representing Summit County and Summit County Sheriff Fothery. For Barberton to win, they must point to a statute requiring Summit County to house, at Summit County's expense, Barberton's revised code misdemeanors arrestees. They can't do it. They admit they can't do it, and the trial court found the same. This court should find the same as well.
Counsel, let me stop you just like I did the appellant. I would like to have a better understanding of the procedural posture here, because both sides are saying the court ruled in a certain way, declared something, but I'm not really seeing the declaration. I'm seeing that the case was dismissed.
Excuse me.
I think that's right, Your Honor. There was a complaint for declaratory judgment. We filed a motion under 12b-6, a motion to dismiss. There was an oral hearing set on that motion to dismiss based on the facts as we understood and as we argued, that no set of facts based on the complaint could find relief for Barberton. There were some standing issues. I believe Mr. Corrado accurately described those standing issues. They don't relate to the city of Barberton.
Yes, and I'm specifically referring to the court's last page. And the court says, it is well settled in Ohio that courts will not issue advisory opinions. To that end, courts must avoid giving opinions on abstract propositions. And then it says, even assuming the facts alleged in the complaint are true, they do not entitle Barberton to the relief requested. Defendant's motion to dismiss is granted. Is that an actual declaration, or is that just a dismissal for lack of justiciability on a declaratory judgment action?
We understand the dismissal, Your Honor, to be on the merits. And what I mean by that is essentially what Mr. Corrado said, which is Summit County has no legal obligation to house the city of Barberton's municipal arrestees on revised code violations.
Thank you.
The city's cited authority, which includes the non-binding Toledo case, depends upon Chapter 7 of the revised code. But a county may only do what the revised code permits it to do. That authority is generally contained within Chapter 3 of the revised code. Plaintiff cannot use municipal corporation statutes to conclude that it has no obligation to operate a municipal jail and that the county is required, without discretion, to incarcerate individuals arrested by Barberton, especially when Barberton has chosen to operate a municipal jail. The baseline of all—
let me stop you here. What if Barberton closed their jail tomorrow?
I think that's a fair question, Your Honor. Well, first, my understanding is that Barberton's jail remains open. So to the extent, we're positing a hypothetical situation, courts generally won't issue advisory opinions. But I think what you're getting at, Your Honor, and please correct me if I'm wrong, is essentially, does that line us up with Toledo?
Well, I think that's part of it. That's part of the issue, but there's more, but yes.
Certainly. And so to discuss Toledo a little bit, we think it's distinguishable for the reasons that the trial court outlined and for the fact that Barberton does operate a municipal jail. To the extent the court believes these cases are not distinguishable, we do believe the City of Toledo decision is incorrect. We believe it misapplies a county's authority. And under that realm, we think there's two avenues for the court to handle the Toledo decision. The first is to find, like the trial court did, that these are distinguishable. And the reason why they are is that, as has been discussed, Barberton does operate a municipal jail. The City of Toledo did not own or operate any type of detention facility. And because of that, the 6th District found that 75203 didn't apply. It does here. And so holistically, we believe the proper way to review these statutes is in conjunction with Revised Code 30517, 75302, and 75303. That provides Barberton with one of two options. First, they can provide for a jail within the municipal corporation, sustain all persons sentenced to or confined in that jail, or they can contract with the Board of County Commissioners for the care and maintenance of those persons by the sheriff, including the revised code or municipal code violations. And to that point, Your Honors, 75302 or 03, which references 75202, makes no distinction between revised code misdemeanors and municipal court ordinance misdemeanors. It just says, quote, convicted and sentenced for misdemeanors. We generally completely disagree with the assertion that Barberton can institute city incarceration policies as desired and require the county to absorb the entirety of municipal incarceration costs and liabilities.
Well, correct me if I'm wrong, but it seems like, in my recollection, in my past days as an attorney and as well as a trial judge, municipal judge, the whole point was if you could charge under the local ordinance, then the city is going to get the fines. Whereas if you charge under the revised code, they're not going to. So there was always incentive to charge under the local ordinance. However, in this situation, I don't know, but I would assume probably that Barberton has made the determination, well, it's we're not getting that much in fines. It's not to operate a jail, so we'll just charge under the revised code. You don't have to reply to that, but is my understanding correct that if you charge under the ordinance, then the municipality keeps the fine?
At a high
Or the
level,
vast majority of it?
I think the vast majority, I think that's accurate. I think there are still some additional costs between a municipal court or a county court based on whether it's revised code or ordinance. But I think at a high level, that distinction is correct. I will tell you the 6th district and what we believe Barberton may be doing here. The city of Toledo essentially said, we're not going to charge anybody under ordinances. We're going to charge everybody under the revised code, and county, you have to deal with it. And so, we think.
Well, does the municipality have the right to do that? That's different than who pays for anything. But don't they, as a city, have the inherent right through their judicial system, through their law enforcement and so forth, to charge in the way they seem is best for their citizens?
It's their choice. That's absolutely correct, Your Honor. A Barberton police officer could effectuate an arrest and charge under a municipal ordinance or revised code. And quite frankly, we think that authority in and of itself supports our argument that then the county can't be held fiscally responsible for the entirety of a city of Barberton arresting decision. And the reason for that, Your Honor, is that a county's authority is simply not presumed. A county may only do what statutes allow it to do. There is a statute, 307-15A, which would allow Barberton to contract with the county to hold its inmates, and then the county may do so. And this goes back to an Ohio Supreme Court decision, I think in the 90s. It's cited by the trial court, Geauga County versus Monroe, which says, we encounter the unquestioned proposition that a county does not have the authority to regulate unless the General Assembly affirmatively grants it. Because this presumption is against authority, the grant must be strictly construed. A county exercises only limited authority. Now, this is different than a municipality. A municipality presumes inherent regulatory authority under the Ohio Constitution. And the real issue with Barberton's briefing, both at the trial court and before this court, is that Barberton simply misapplies a county's authority. And that's where the trial court got this right at the beginning. Barberton's analysis is backwards. It does not follow the Supreme Court of Ohio's precedent on how to determine a county's authority. Barberton argues that because the housing of misdemeanors is not reserved for the city, it defaults to the county, despite Barberton admitting that there is no revised code provision that grant or requires the county to do so. This is wrong. The county's argument is straightforward. Summit County may only do what the revised code permits it to do. If the revised code does not require it, then Summit County is not required to perform that function or service. That being said, the county may choose to perform that function or service if it is allowed to do so under a contract. 307-15A permits this exact type of agreement. 307-15A is a may, not a shall. It's the county's discretion. Simply stated, there is nothing in chapters 307, 341, 715, 717, 753, 1905, Title 30 or 2935, or anywhere else in the revised code that requires the county to undertake Barberton's incarceration selections. In fact, Barberton's brief admits on multiple occasions that this is right. Simply stated, the county cannot be required to accept these revised code misdemeanors. Now, that being said, there are several points with Barberton that we actually agree on in their brief. Revised Code 30701A says that a Board of County Commissioners shall provide for a jail if it's necessary. We agree. Title 7 provides that a municipality may establish a jail. We agree. Barberton continues to operate its city jail today. This court may be interested and may want to ask Barberton if the city has ever charged other municipalities to utilize its city jail, or if it contracts with Summit County for other political subdivision services. We also agree that Ohio law does not require municipalities to contract with the county for jail-related services. It's the municipality's choice. Where Barberton is wrong is the next step. They infer or imply based on those sections that there's a third option, which is to force the county, despite there being no statute requiring it, to accept Barberton's revised code arrestees. Barberton opines that the lack of a statute requiring the county to house these misdemeanants creates the implication that the county is required to do so. We believe that's backwards and actually fatal to their case. If the General Assembly did not impose this obligation upon Summit County, then no obligation exists. That gets us to another point. Contracting for jail facilities occurs throughout the state of Ohio. The financial implication to Summit County alone, we believe, is north of $6 million a year, and we don't think it's a stretch to say that the overall answer to this could be upwards of $50 million a year. We also believe this is a common practice. Data collected by Summit County indicates that Cuyahoga County charges a jail bed rate of $99 a day. Montgomery County charges a jail bed rate of $61 or $73 a day, depending on the type of inmate. We don't think Summit County is the only county doing this. And that makes sense.
The arguments you made, aren't those more legislature arguments? In other words, the city should, the city council and really even the state, since everybody seems to agree there's not necessarily a statute on point, period.
I think the best answer to your question, Your Honor, is that if there is no statute, and there's not, then it's not the county's responsibility, which means it goes to the city. Now, to answer your question, if the legislature believes that it should be the county's responsibility, then they should add statutory language to that effect. But right now, nobody, including the city of Barberton or the trial court, has identified any statutory requirement that forces the county to house Barberton's arrestees. Now, Barberton's attorney made a reference that we don't dispute the findings of the Toledo case in the 6th District. We actually don't agree with that. We do believe that this court can distinguish the findings of the city of Toledo and find in our favor. We also realize that the court could affirm the decision of the trial court based on legal theories that may have not been presented in Toledo and declare a conflict between this district and the 6th District. There's really two areas where we think the 6th District went astray. And both of those were because the 6th District went too deep but didn't go far enough. And if you'll allow me a brief minute to explain that. What I mean—
I have about 2 minutes. Okay.
Thank you, Your Honor. What I mean by that is that the 6th District conducted an exhaustive review of 75302A and 190535. They started in the weeds with those two sections. What wasn't done was a general overview of the restrictions, abilities, and limitations between that of a county and of a municipality. We think, had we started with the Supreme Court's guidance, which is essentially a county may only do what it's authorized to do, that actually supports and is the bailiwick for what we're presenting to this court. Instead, the 6th District found that 190535, quote, implicitly relieves municipal corporations from the obligation to pay for incarcerating state law violators. We believe that's wrongly decided because it did not require a statute to authorize an action of the county. Instead, the 6th District found a duty upon the county by inference and negative implication. We believe that's insufficient based on prior guidance from the Supreme Court of Ohio. There's simply no grant of authority to the county from the General Assembly to perform this function. And the second point about the 6th District, they went pretty far in 75302A and 1905-35, but they didn't finish the analysis of 75302, and specifically subsection B. There's language in subsection B that authorizes municipalities to charge individuals for jail-related costs. That subsection explicitly references incarceration statutes in 2929-37 and 1905-35. There would be no reason to include this language unless the intent was for the municipality to pay a county to house their arrestees. I know I'm running up against the clock, Your Honor. May I briefly conclude? Thank you, Your Honors. Barberton wants this court to require Summit County to pay for Barberton's decisions on incarceration. In so arguing, they fundamentally misstate a county's authority. Summit County may only do what a revised code permits it to do. This statutory starting point grants it the power to do many things, but necessarily removes any consideration of what a municipality may do through its implied regulatory authority. Barberton admittedly is unable to identify a revised code statute that forces this obligation upon the county. The county thus has no duty to do what Barberton asked it to do. For those reasons, Your Honors, this court should affirm the decision granting from the trial court that granted the county's motion to dismiss. Thank you.
Thank you very much. The appellant will have 2 minutes and 23 seconds.
Okay, thank you. Just very quickly, this idea that we are required to point to an express statute that places this obligation on the county, I would suggest is not the legal standard. There's nothing that requires that we point to an express statute. We have to look at the statutory scheme and see whether it does authorize and require the county to undertake these responsibilities. There's a number of statutes that require the county to maintain a jail, to house a jail, to pay the costs for its jail. A lot of those are outlined in the various attorney general opinions that we cited in our brief. So we don't have to point at a specific statute or a sentence in a specific statute. If you had to do that, then there would be no rules of statutory construction. Statutes have to be read together. They have to be harmonized. And then a conclusion then has to be drawn from that. And that's exactly what the City of Toledo case did. As it relates to 3505-15, very quickly, that statute has nothing to do specifically with jails. It doesn't mention jails. It doesn't require contracts to be entered into. It doesn't say that in order for a municipality to be able to place misdemeanants in a county jail, there has to be a contract between the county and the city. It doesn't say any of those things. It says a county may generally contract with a city to provide services. There are many more specific statutes that address the responsibilities for incarceration and how those responsibilities are divided between cities and counties. So we don't believe that the standard is that we have to point to a specific statute. We think you've got to read the statutory scheme together and harmonize it, just as the City of Toledo did. We wish that maybe some of the distinguishing factors that were pointed out today for the first time, or at least claims of distinguishing factors, had been briefed. We would have liked to have had an opportunity to respond to those things. This is the first time we have heard that in the last 10 seconds. But having said that, if there's no further questions from the court, the appellates would then just ask again that the trial court's decision be reversed and remanded with instructions to enter judgment in favor of the city.
Thank you. Thank you both for your arguments and the presentations to the court this morning, and again for appearing via Zoom, and for Judge Baldwin for sitting in for one of our judges too. And the court will take the matter under advisement and will issue a written opinion that will be sent to both sides. And obviously, as we're doing all this stuff electronically today, you can also check the Ohio Supreme Court website, because we release our opinions there electronically. Our next scheduled court hearing for oral arguments is Thursday, May 2nd, in person in Akron, Ohio. So thank you very much. Have a great day, everyone.
Thank you.
Thank